All right, thank you, Madam Clerk. Good afternoon, folks. This is the afternoon session of the September session of the Tennessee Court of Criminal Appeals. Welcome, everyone. I think we just have one case on the afternoon docket. My name's Robert Wiedemeyer. I live here in Nashville. My colleagues on my right, Judge Robert L. Holloway, Jr. From Columbia, Tennessee. On my left, Judge Kyle A. Hickson from Knoxville, Tennessee. You folks have probably been here before, but I'll quickly go through the ground rules. 20 minutes per side. If you wish to reserve some rebuttal argument time, announce that at the beginning, and we'll take that into account, and the light will tell you when your time is about to expire. We have read the briefs in this case and all the other cases that we've had today. I think that's all I need to say before we get started. Any preliminary matters?
No, Your Honor.
Call the first and only case, please.
State of Tennessee versus Joshua Lee Shaw.
All right, good afternoon.
Good afternoon. May it please the court, Amber Schlatter on behalf of the appellant, Joshua Lee Shaw.
All right.
I would like to reserve 4 minutes for rebuttal.
Excellent. If you would please speak as loudly as you can and not be yelling, because I don't hear that well, and it'll help me. I want to hear what you have to say. So
Yes, Your Honor.
these other two young judges have no trouble with that, but I'm getting up there in years, so speak up and you may begin.
Yes, Your Honor. Before I get into the substance of the issues here, I would like to note that in preparing this brief, the General Assembly did amend the statute for expungement in 2025, and so I will be proceeding today under the 2024 statute. However, the substance did not change. It was just the statute TCA code that would change what is in the brief. I will be proceeding under the 2024 statute.
Thank you.
There are two issues before your honors this afternoon for review. The first being Mr. Shaw's expungement or his eligibility for expungement under TCA 4032-101K. The second being his eligibility for expungement under 4035-313. However, if your honors do not have specific questions regarding his eligibility under expungement for 4035-313, I would like to direct this argument to his eligibility for expungement under 4032-101K.
That's fine. Go right ahead.
Actually, let me ask you about, you're speaking of the judicial diversion.
Yes, Your Honor.
Was he given judicial diversion?
It appears that during the initial plea agreement, it was notated on the plea agreement paperwork that Mr. Shaw was supposed to receive judicial diversion as a part of the agreement. However, it appears there was a clerical error on the judgment, and this was before this judgment was entered in 2006, so it was before there was an application required, which didn't start until June of 2012, and an order of deferral, or 17A, of the Supreme Court was not enacted until November of 2011. We reached out and tried to get the colloquy of the original plea when it was entered. However, it was almost 20 years ago, and there was no recording of the proceedings. And so it is unclear. It is our argument that he was supposed to receive it. However, there is no finding, and we understand that the technical record of this appeal is that there is a judgment that shows he was convicted without the benefit of receiving judicial diversion. And that's why I would prefer to direct my argument for the
Sure, I just wanted to clarify that. Thank you.
Sure, absolutely. And so under Tennessee Code Annotated 4032-101K, a petitioner is eligible for expungement of 2 or no more than 2 offenses, as long as each offense is either a misdemeanor and 1 felony or 2 misdemeanors. They're eligible for expungement if the offenses are both eligible under Section G1 of the statute. the offenses occurred prior to any offense which would be ineligible for expunction, and depending on the offense, whether 5 or 10 years have elapsed since the completion of the sentence, and the petitioner has fulfilled all the requirements of the sentences imposed by the court for each offense, which would include payment of fines and court costs, completion of any imposition of incarceration or probation that was imposed, and meeting all conditions of supervised or unsupervised release, as well as remaining free from dependency of alcohol or drugs for no less than 1 year if required by the sentences imposed. The petitioner must not also have not been granted an expungement under sections M, K, or G of the statute to be considered eligible. It is undisputed that Mr. Shaw meets every single one of these requirements, with the exception of meeting the conditions of his supervised and unsupervised release. The question, or the state alleges that Mr. Shaw has failed to meet the conditions of his supervised and unsupervised release because in June of 2008, Mr. Shaw was served a violation of probation warrant, which he ultimately pled guilty to in January of 2009. At that hearing, Mr. Shaw was reinstated to probation and was furloughed out to a rehab facility where he completed 8 months of rehab, and then once that was completed, he was sentenced back out into probation for the remainder of his sentence. I think the question becomes whether an individual who has failed to meet the conditions of his supervised or unsupervised release, if it's possible for someone who has not met those conditions to have a successful completion of their probationary sentence. And I would submit to this court that it would be impossible for an individual who has failed to meet the conditions of his supervised or unsupervised release to have a successful completion of their probation. An unsuccessful completion of probation, or someone who has not met the conditions of supervised or unsupervised release, would have a revocation, a complete and total revocation of that probationary sentence, and they would be sentenced to serve the original sentence.
So then this is purely a matter of statutory interpretation. What does it mean to successfully complete your probation per the statute, basically?
Yes, Your Honor. With that being said, I would direct Your Honor's attention to page 22 of the technical transcript, where you will find a letter dated April 9th of 2024 from the Tennessee Department of Correction that states that Mr. Shaw successfully completed his probation on August 24th of 2010. And with him having successfully completed that probation, I would submit to you that he met all the conditions of his supervised and unsupervised release. And as such, there should have been a presumption that was given to him at the original hearing on this matter in favor of granting his expungement. Under Section 4032-101G5B, the trial court is tasked with weighing the interest of the petitioner against the interest of justice and public safety, provided that if the petitioner has met the requirements laid out in the statute to be an eligible petitioner for expunction, there is a presumption that arises and is to be given to the defendant in favor of granting that expungement. The trial court failed in applying this presumption to Mr. Shaw, and on top of failing to grant him this presumption or apply this presumption in determining whether he was eligible for expungement or not, they also made several errors in their weighing of the petitioner's interest versus the interest of justice and public safety. The first error that I would direct this court's attention to would be the trial court's concern about the length of time that had taken place between the completion of Mr. Shaw's sentence and the application for the expungement of his criminal record. On page 12 of the transcript from the original proceeding, lines 15 through 18, and I quote this so I don't mess it up, but the trial court says, "Are we going to set cases for expungement 10 to 15 years after somebody is given a chance to expunge their record when they pled guilty? And the answer to that question is yes, because it's a statutory requirement. Under the statute, to be eligible for expungement, if the offense seeking to be expunged is a Class D or C felony, the petitioner is required to wait 10 years from the date of the completion of their sentence before becoming eligible for that expungement. And so to hold a statutory requirement over Mr. Shaw's head and weigh that against his interest in granting the petition to expunge is clearly erroneous. The second error that I would point this court's attention to is the trial court's perception of the leniency that was already given to Mr. Shaw and weighing it against him in the interest of justice. So the trial court at this hearing expressed great frustration at the leniency that was given to Mr. Shaw, and the leniency that he refers to, he says he's given 4 chances. The first being an amended charge to which he pled guilty to. So Mr. Shaw pled guilty to an amended charge of attempted possession of Schedule II controlled substance, as well as the simple possession of the Schedule VI, which is that A and C felony. But it was amended to the attempted possession. I'm not sure where the court sees that is being given an amended charge to plead guilty to could be considered leniency, but it also could be out of necessity. And a lot of times, without digging further into the facts of this case or knowing the facts of this case, it's hard to say that the trial court, when granting this, for them to say that it was lenient for him to be able to plead guilty to an amended charge, the trial court didn't know the ins and outs of this case. He wasn't privy to the negotiations between the prosecutor and the defense attorney at the time that this plea was being negotiated. A lot of times when pleas are amended from the original indictment, it's because there's holes in the prosecutor's case. Well, what do you do to plug the holes? You amend the charge. And so that's not leniency, that's necessity. The second chance that the trial court expressed frustration over is that Mr. Shaw was given a sentence of probation. So he was sentenced to 4 years, all suspended to supervised probation. I understand that probation is an alternative sentence to incarceration, and one could view it as leniency. However, it is still a statutorily prescribed alternative punishment, and with the imposition of probation, there are still real and substantial restrictions on somebody's liberty. It's still a punishment. And again, there are multitudes of reasons as to why someone would be given a sentence of probation rather than incarceration. Some of it is we reserve incarceration for the most dangerous offenders, the offenders that we are trying to keep away from the public in regards to their safety.
Help me with the record if you could, because you're saying the trial court erred by finding him to be an ineligible petitioner as a matter of law based upon his prior violation. Is that true?
Well, I think there's some disagreement about that. In the transcript of the original proceeding and in the order that followed that proceeding, the trial court does state on the record that although he may be eligible, it is not imperative on this court to grant the expungement. And I think it's just
So that's how we get into this extra layer of analysis that you're
Yes,
going
Your Honor.
through right now. Could we go back to that first step, the one we said, okay, this is a matter of statutory interpretation. Tell us why you win on that.
Why we went on that? Because I think it would be impossible for an individual to have a successful completion of your probation had you not met all the conditions. And I think that rolls nicely into, I said in my brief that Tennessee law doesn't require an unblemished probationary period. It's understandable that people who are sentenced to probation, it may be that they have a drug addiction, but there's room for human error. And I don't have an argument prepared about the probation statutes, but there's difference between technical violations, zero tolerance violations, and you have, you know, probation is, for a first violation, you have 15 days. And then you're given another opportunity to come back out on probation to continue to meet those conditions.
What does the expunction statute say? What does it say makes you eligible or ineligible?
It says that if you fulfilled all the requirements of the sentences imposed by the court for each offense, including payment of court costs and fines, completion of any term of probation or imprisonment, meeting all conditions of supervised or unsupervised release, and remaining free from dependency of alcohol or substance abuse for a year or more, if necessary, from the imposition of the sentence imposed by
So
the court.
I'm guessing the state is gonna stand up and say, well, he pled guilty to violating his probation. He was not revoked completely, but he does have that as part of his record on this case. So he did not comply with all of his conditions. So how do you think the statute still allows to make him an eligible petitioner?
I think the meeting conditions of supervised or unsupervised release is a case-by-case basis. I think it depends on, there are certain conditions that you have to meet, and once you meet those conditions, you'll have a successful completion of probation. If there are conditions that are unmet, there's punishments that can be invoked. You can have an extension of your probation. If you're charged with a new criminal offense, you can have, you know, an additional sentence placed on top of that, or your sentence again is extended. But if you've met all the conditions, your original sentence, the 4 years that Mr. Shaw was sentenced to complete, he met the conditions in order to complete that 4-year sentence in 4 years and had a successful completion of that probation.
So the only way you could be ruled ineligible under your reading of the statute is if you were revoked to serve the balance in correction?
Yes, Your Honor.
Maybe it's an issue of semantics, but to me, if you look at the original judgment where he was sentenced to 10 years, and I assume they have marked on that judgment TDOC, then that sentence is suspended and he's placed on probation. And so in my mind, there's a difference in successfully completing service of your sentence, which he did, and successfully completing the probation part of that sentence, which he did not because he had a violation. He was placed back on and was able to complete his sentence. And so I guess I'm getting confused on, you say he was sentenced to probation, and I understand that's language that is often used, but he's actually, I think, sentenced to service of the sentence, but that service is suspended. What do you say about that?
I believe that the service was suspended and the suspension of that sentence was the imposition of his sentence.
Maybe just semantics, but I'm having a hard time wrapping my head around, how you successfully complete probation when you violate probation.
My time is up, so.
You're basically, see, help me understand this, but I think what you're saying is, if you're put on probation for 5 years, if at the end of that 5 years, you're not on probation anymore, you haven't been ordered to serve your sentence, no probation officer cares what you do next, the judge has no interest in you anymore. Even if during those 5 years you had 2 or 3 slip-ups, including VO violations of probations, this, that, and the other, you have successfully completed that 5 years, even if there were some slip-ups along the way. And now that you have completed it, you should be entitled. Now all we're talking about is, do you get the record expunged or not? And your answer is, yes, you should.
Well, the statute still leaves discretion to the court to determine whether there is a genuine reform. And I think then you would get into the legislative intent of why the expungement statute was enacted. And there you would go into that, weighing the petitioner's interest against the, interest of justice and public safety. And in that, you would look at whether the individual genuinely demonstrated reform. And in this case, Mr. Shaw did demonstrate genuine reform. There were letters of support from community. He has remained conviction-free since the completion of his sentence. He successfully operates his own business. He helps people who have struggled with the same addiction that he had in the past. And the trial court, rather than listening to that evidence with an open mind and an open heart, only used that as a reason to revisit his notion that he's been given too many chances already. He read a letter of support from an individual in the community that said, I believe Mr. Shaw is well deserving of a second chance, and said, well, he's been given plenty of chances already. And instead of reading that and this man has demonstrated a genuine reform and is the epitome of why the expungement statute was created in the first place, he was caught up in a perceived leniency that was already granted and didn't care that he had a genuine reform. And so I would ask this court to review that and reverse the trial court's decision, if there are no other questions.
We'll give you you can have your rebuttal time since we ask a lot of questions. So.
Thank you, Your Honor.
Yeah, thank you. Good afternoon, General.
Good afternoon. May it please the court, Liz Evan on behalf of the state. I just want to dispose of the diversion issue very quickly. Judge Hickson, my friend here, has conceded that there is nothing in the record that indicates that he was ever given diversion, so we'll just set that to the side and discuss this substantial, rather successful completion argument. The statute says all.
Let me stop you there.
Sure.
Because the reason is we had a case maybe 2 or 3 months ago up here from the same bit, Sumner
Yes.
County, and there was a good, and we ended up reversing it. I think there's a good bit of, is this judicial diversion or is it
Right.
not judicial diversion? And
Right.
we discussed longer than I'd like to think about the idea that if it really is judicial diversion, then there is no conviction, no
Correct.
judgment, as long as the defendant successfully completes the period of probation, and that's it. So you're saying, but there was, in that case too, there was confusing language. Everybody, I kind of think
Yes.
you're familiar with the case.
I am familiar with the case.
Okay,
St.
you're
Vincent,
more
Your
familiar
Honor.
with it
Judge Easter
now.
wrote that one, and the two of you were on it, yes.
Yeah, I was
I'm well
thinking
aware.
Judge Holloway and I both, maybe Judge Easter was the,
Yes.
he may have written it. So you're saying unequivocally that issue is not in this case?
That is not in this case,
Okay,
Your
good.
Honor. There were actual judgment forms entered.
Okay.
There is no plea colloquy or plea agreement in the technical record. Whether those ever existed, they are not in the record. The record preponderates against any finding that he ever received diversion. So
Okay.
we'll just set that to the side.
All right, I apologize for interrupting, but I want to make sure on that. And you go right ahead.
That's fine, Your Honor. So the statute here, as far as successful completion, says all requirements, and all means all. All requirements means meet all the conditions of supervised release. And so the state would submit that whether or not you're revoked on a technical violation or non-technical, you have not met all the conditions of supervised release.
What if he missed an appointment?
If that has been adjudicated as a violation, then you have not met all the requirements of release, or of supervised release. So that is the state's position, in contrast to the position where you can violate 10 times, and as long as you're put back on probation, you're fine.
What if he's misses an appointment and is given a formal sanction in lieu of an arrest warrant according to their matrix?
I am not familiar with that procedure, Your Honor, so I could not speak to that particular issue as far as if that's an adjudication of a violation. I'm simply just not aware of it. I would have to do some research for you on that particular
Sure.
issue.
Well, just under the Public Safety Act, when someone's on probation through the department, they have an internal matrix that they use, and if someone violates in what we would probably term a technical manner, they could be sanctioned within the department without bringing it back into the judiciary, without filing an arrest warrant. So what if someone has a whole list of sanctions throughout the course of their probation, but they were never formally adjudicated via an arrest warrant and VOP proceedings?
If there has not been any kind of due process procedure along with that, I would be concerned about that being a bar.
But the
Because
statute says all conditions.
that's true, but someone can't just be accused in our judicial system. They have to have an opportunity to be heard on that issue.
Well, I understand they have an internal procedure to challenge sanctions if they feel they've been improperly sanctioned. So wouldn't that be adequate due process under the circumstances?
That is a very good question. I suppose that would probably be the case then if someone has not challenged that, has in essence admitted that violation through the sanction process.
They would be ineligible for
Expunction, right. This is a statutory grant of largesse. This is not something someone is entitled to constitutionally or anything like that. This is something that the legislature has enacted, and when they say all requirements, they do know how to say substantially comply. So if they wanted to say substantially comply, like they do with the sex offender registry, for example, they could have said that. If someone had substantially complied with the terms of their probation or supervised release, that's not the language they used, and so we're just looking at the plain language argument here, and the state would submit that he is simply ineligible. Now, if this court decides that he was eligible, then we turn to the discretionary decision that Judge Gay made. And he did look at he noted the judicial diversion, which again, we believe is not supported by the record. But the other three determinations being he was pled down, he was granted a suspended sentence, and when he was revoked, he was placed back on probation. So we would submit that that's not an abuse of discretion.
Let me ask you this. Was there any evidence I assume there was a hearing about this?
Yes.
Was there any evidence presented about you said pled down, about the plea, dropping a charge or going down?
There was not any evidence presented at all. It was just
So,
argument.
as Counselor has pointed out, is it legitimate to just assume, okay, you pled to a charge that was lesser than the one you were charged with, so you got a break there. That's one, you got a huge break, without knowing anything about the case or what happened or anything?
I think that the record does not preponderate against that finding, like as it does with the judicial diversion finding. So
Can't
Okay.
the most you say on that is that the record's silent? I mean, couldn't it be
Sure.
like Ms. Schlatter said, that maybe it was pled down not because they were giving him a break, but because that's all the state could prove?
that is a possibility, Your Honor.
And absent additional evidence, wouldn't it be improper for the trial court to consider that, one way or the other?
I think that the question being, was it an abuse of discretion for him to say that the interests of justice weigh against this? And I would submit that it's not, that he was granted a suspended sentence, he was revoked and returned to supervised probation. And so because of those things, even if the other two might have been an improper consideration, this was sufficient for him to say, no, you don't get an expunction.
Why should it be counted against him at this point that he received a suspended sentence? I'm assuming from the little I know about his criminal history that he would have been presumed to be a good candidate for alternative sentencing when he received an alternative sentencing. So if the law says that he is presumed to be a good candidate for that, why should we turn around and say, well, that was some sort of break that you didn't really deserve, and I'm going to hold it against you now?
I think, Your Honor, in context of him then violating that and turning around, it's not just the one thing. It's not just that he was eligible for a suspended sentence. It's that he went out and then violated.
Well, and I'm with you there. He shouldn't have violated. He was
Right.
adjudicated guilty of that. That shouldn't have happened. But everything else, I mean, are these really considerations that were proper in this context, given the proof that was presented?
Consideration that he was given a suspended sentence rather than,
That he pled to a charge that was lesser than the indicted offense. We don't know any of the circumstances of that. That he received a suspended sentence, which most likely, I would think on this record, the statute would tend to say that he was deserving of receiving that. Those two things in particular are really grabbing me. Is it appropriate for the trial court to consider it in that way?
I think that it is not an abuse of discretion for him to consider that. That would be my position, Your Honor.
Well, if a trial judge considers something that he's not supposed to consider,
In
that's
the
an abuse
context,
of discretion, I think.
and I understand that, but in the context of, if it was just those things, I think that might be a different argument, but because he violated and then was placed again on supervised probation in the context of you don't get to the second set of probation unless you have the first.
Okay. I understand what you're saying.
Yes.
As long as there's one solid thing that he's basing it on, that he clearly did not abuse his discretion, then the other ones don't affect the ultimate outcome. That's what
Yes, Your Honor, that
Okay.
would be the state's
Okay,
position.
I got you. I'm not saying I agree with you, but I understand
You're
your
understanding my
point.
position, yes,
Yeah,
Your Honor.
that's right.
So unless there are any further questions, we would ask this court to affirm.
I have another question for you.
Sure.
It's more of a philosophical question. And thank you.
I'll
for
do my
being-
best.
Yeah, thank you for being patient with us. In my mind, I've always thought of the expungement statute as, if you do everything you're supposed to, it's more or less, and it's for certain offenses. Now, a real serious offense, you're never gonna get that one expunged.
Right.
But certain offenses, and this case is one of those, if you manage to get through to the end of the sentence here, and you're, like I said earlier, no probation officer cares about you anymore, the judge doesn't care what you're doing, you're done with everything. I've always thought of it as, and I know this is wrong, but I always thought of it as sort of an automatic, just fill out the form and get your record expunged, because it was such a relatively low-level offense. But here's where we get to the philosophy part. We, as a society, would like to have people who have made some mistakes, but done their time for it, and the classification of the crime that was the mistake is relatively low. We would like them to be able to go forth thereafter without being burdened by this record of this criminal conviction. And obviously, that's hugely helpful to the individual. And what I understand the philosophy of, as I understand, what little bit I understand about what this, in this case, there was a determination that, well, the interest of justice and the message, what we want to send out to other offenders, I guess, is you're not going to get this expungement unless you have basically a perfect probation record.
Correct.
And I mean, I don't know, that I had never really thought of it like that, and I know, in fact, to be honest, hearing all these requirements was kind of a new thing in my mind, and I know I'm expressing ignorance here, and I apologize, I shouldn't even be saying this, but the philosophy of the expungement thing to me I never thought of it as requiring a judge to try to decide are you worthy of this? And so basically, the way the state interprets this statute is, you check off all these boxes, and you have to have the judge decide, yes, you're a worthy person to have this record expunged.
Your Honor, that is what the statute requires.
Okay,
So yes,
okay.
the plain language of the statute says all requirements, all conditions, and then gives the judge some discretion here.
Okay, and if I know from experience that it involves some people that I won't mention today, but a minor offense, like relatively minor, like a speeding ticket, which does not involve me,
Never.
but that can be dismissed and expunged without any. The TBI looks, and if there's no prior history, they say, yeah, expunge it. And it's just more of a clerical thing, just bam, it's expunged. And maybe that's the reason I'm was thinking that it didn't require this judicial determination of worthiness. But I guess, I don't disagree with you. The statute says that's what it is.
Right.
So,
And of course, then the speeding ticket being a civil versus a criminal violation, and that sort of thing is going to.
yeah, excellent point, yeah.
Yes.
So that speeding ticket for this person that I won't name was not as bad a deal as I thought, since it was civil.
Yes, we're talking here about a felony.
Okay,
So.
okay, thank
I
you.
thought it was gonna be a traffic light violation.
No,
That's a joke from the morning docket.
yeah,
Goodness.
those of you who missed my
Yeah.
routine, yeah.
All right.
I'm not here all week, though, so,
Let me ask you, General, is the statute the eligibility statute that we're talking about here, is it at least susceptible to the reading that they're giving it?
No, Your Honor.
I mean, he had a 4-year sentence, he completed it, paid everything.
That would go into the spirit of this. If someone could violate probation 10 times and yet still be returned to probation every single time, be revoked 10 different times, but as long as they were never incarcerated, they completed successfully, that can't be what this means. They have to meet all the requirements here. And so, as unfortunate as it may be in this particular case, or whether or not we like this particular outcome, it's just simply what the statute says, Your Honor.
What if he was given a sentence to serve, 4-year sentence to serve?
I don't know. I don't know how that plays into the statute, Your Honor. I haven't.
Then there would be no other conditions, correct?
Presumably, unless he was placed on something afterwards.
Yeah, I was just thinking, what if he had infractions while he was in correction custody?
That's a good question. Maybe that case will come up one day and we can discuss it. Now you got me curious.
I'll hold my breath for that to happen.
Yes.
yeah.
So if there are no further questions,
No, thank
I'd
you.
ask this to affirm.
Okay, Your Honors, I would like to just address quickly, my opposing counsel has mentioned several times, let's let them violate their probation 10 times, and that is not statutorily something that they would be able to do. After a fourth technical violation of probation, there is a mandatory revocation that is required. And so
Wasn't there a partial revocation in this case?
there was a partial revocation to credit for time served. He was served with the warrant in June of 2008, sat without a bond until the hearing in January of 2009, in which they revoked him to time served for that period and then reinstated him back out into probation.
So the problem is sort of the opposite side of the coin, if you look at Judge Wiedemeyer's statement. The appellant's position is, as long as there's not a full revocation and the defendant is ordered to serve the balance of the sentence, then he has successfully completed probation or probated sentence, right? So her example, where there's 10 violations, is accurate. Because if he is reinstated each time and placed back to serve, on probation to serve the balance of his sentence in that form, then he has successfully completed probation. Is that your argument?
After the fourth violation, there's a mandatory revocation of the probation, which he would then be required to serve the remainder of his sentence. And so there is not a situation in which an individual or a defendant would be able to have 10 violations of probation. Maybe if he has multiple probation sentences out of different counties and he's serving multiple different probations and you wanted to add those together. However, on a singular such as this, you would be limited to a fourth technical violation on your sentence before being mandatorily revoked to serve the remainder of your sentence.
What's your position on the state's statement that, okay, maybe the trial judge shouldn't have considered the fact that he pled to a lesser offense, and maybe the trial judge shouldn't have considered the second one, which jumped out of my head just now, and but they've got this, there was a violation. So, what was the second one?
The granting of probation.
Yeah. So, what we have at this level, the trial, it's an uphill battle for the defense to show us that a trial judge used his or her discretion. That's a tough thing to do. Your position, I assume, would be, if the trial judge did miss 2 out of 3, and then maybe there were some others in there, but you think that's enough for us to say he abused his discretion, correct?
Yes, Your
And then if we say that, what remedy do you want us to remand back to this judge and let him reconsider? Or do we have the authority instead of that, which for something tells me you might not prefer that view, then you would ask us to say discretion was abused and expungement should be granted, end of case?
Yes, Your Honor.
Okay.
I would also like to state that it would be our position that at the time of the probation violation hearing, by reinstating Mr. Shaw to probation, he at that point deemed him worthy of another opportunity to meet the conditions of his probation and successfully complete that, which he did by virtue of that letter from the Department of Correction, which states that he successfully completed that on August 22nd or August 24th of 2010. And so whether he was having a bad day on the day that he was hearing the petition for expungement and decided he wasn't worthy of an expungement at that time or worthy of a second opportunity, we would ask that this court would look past that and reverse the trial court's decision and expunge Mr. Shaw's record.
All right, I believe that's it. Thank you very much. Both sides did a great job answering the intelligent questions that my colleagues asked and dealing with my questions as well. Enough said about that. And the briefs were well-written also. Thank you. We'll take it under advisement, and in due course, we'll issue an opinion. And I think we're in recess until the October term, correct? It's on briefs, so November term. All right, thank you.